Hello and welcome to this Introduction to International Law online course. My name is Harris and I'll be your guide where I'll be taking you through some of the basics, the fundamentals, and some of the easy to understand popular law behind international law. I'm a law graduate from the University of Glasgow. I graduated with first class honours, and right now I'm a private legal tutor tutoring various different students on different courses and topics, as well as some adult learners, and try and get them up to speed with some of the fundamentals and the basics of law. If you are interested in tutoring or if you have any questions, please feel free to email me. Just as a side note as well as this course, I also have another online course. It's called Introduction to Scottish and Common Law. It's available on Udemy and Skillshare, and you can see the link in the description. So who is this course aimed at? Well, it's aimed at a number of people. So the number one category would be undergraduate students who are studying an international subject at university. Another category could be master's students, the LLM students studying international law, international relations, something similar, and they would like some sort of introduction to international legal concepts. Foreign lawyers will also benefit from this course, as this course can provide you with some very good introductory concepts, especially if you're about to go into this area. And the general public, anyone who is generally curious and wants to find out more about law. So let's get on to the course topics. I've tried to encompass a broad range of topics in this course. However, it doesn't go into as much detail as perhaps a university lecture. So I've tried to be very concise and only cover the main points or the most popular areas that people are interested in. So I'll be first looking at the background and setting of international law, looking at the history of international law, then looking at sources of law, dispute settlement, how parties settle problems, what is there an international court, for example. Jurisdiction, which I'll get onto, which is essentially when does a state have a right to prosecute, and problems that international law might face in the future. Now, I like to simplify all my courses, right? So I can understand some of these words, they can be a bit difficult to understand. So I've simplified all of those topics. So the first one would be, what is the idea behind international law, which will be this lecture. Second one, how did international develop? Where does international law come from? Who settles disputes? How do you decide who applies the law? And what problems does international law face? Okay, so it's much easier when I break down my slides into questions, especially for a lot of people. So let's get into the first lecture, setting what is the idea behind international law. That's me in Mainz in Germany, and I was there doing a year abroad in 2018/2019. And when I was doing my year abroad, I remember traveling and meeting up with lots of other students who were also doing a year abroad, people from Ghana and Switzerland and Italy and France and all sorts of countries. And I think it's easy to overlook just how remarkable a feat this is. The idea that so many different types of cultures and people are able to travel, first of all, from distant lands and meet up together and not only cooperate with each other, but also try and solve problems and be in the same area, be in the same space. Historians estimate that around 10,000 BC, the world was split up into thousands of distinct, very, very distinct cultures, none of which knew about each other. So you could have a small tribe in, let's say, Germany, and yes, they might know about the tribe next to them or the tribes over the forest, but definitely the tribe that was bordering into France or into Switzerland, let alone the African tribes, they wouldn't have had a clue about who these people were. And slowly, the world becomes more and more integrated through trade and other things, and we essentially become one world. So a really good example of this would be, for example, Germany and Japan, right? Today, Germany and Japan, they trade nearly $40 billion worth of goods with each other. I mean, you'd be hard pressed to go to one of these countries, and if you were to mention a German person or a Japanese person, they would pretty much have an idea of what that person would be or where that country is located on a map. This was not always like this. Up until only around the last 1,000 years of human history, Germany and Japan barely knew each other. They had their own institutions, their own systems, their own monarchies, most likely. And so they would be developing themselves without any cooperation at all. You ask a German person back in 1083 what a Japanese person looks like, I doubt he wouldn't even know. The species of Homo sapiens, or human beings, first emerged around Africa and Asia a long, long time ago. They would have had no clue just how big the world was, just how vast planet Earth was, until very recently in human history, where today humans have conquered the entire planet. We pretty much have Homo sapiens in every single area on the planet, or habitable Earth. And even the seas, we've managed to explore a lot of that as well. And because of this, today we have access to all the different types of cultures in the world. Doesn't matter which country you go to, in that country, no longer are there only going to be natives of that land. You will see people from all walks of life. And I'm a prime example of this, of cultures being able to immigrate and move from one place to another. My parents came from Pakistan to the UK and settled here. And now hopefully I'll live my life mostly as a European, no longer as a full-blooded Pakistani. So it's extremely remarkable, this achievement in human history. So here's where we start to relate this now to law, to international law. So what we have now today in the 21st century is a global society. All of the people, or the vast majority of people, are now interconnected in some way or another, whether it is through politics, where we have these internationally recognized states, whether it is through economics, we have these market economies and now they're able to trade with each other, whether it's through science, many of the science programs in different countries, they apply the same scientific principles, the kind of global universal scientific principles, or whether it's through law. We also now, as these individual states are created, we have the same international legal rights and obligations. Each state, each country interacts with each other and applies these same legal principles. And even really, when you look at the domestic law of countries, they're very, very similar. Now, what's really important if you want to understand international law fully, and actually if you want to understand the world fully, is to understand this concept of a state and what it actually is. When I say state, I mean, what actually is a country? So the best way that I can explain this for you is if you take Scotland and England. Now, imagine you are standing right on the border between Scotland and England. If you see that little line there, imagine you're standing right there. Now, it's easy on a map to separate the territory of Scotland and the territory of England. But if you were to actually stand on that border, that's really all you would see, right? You would see dirt and grass and mud and natural terrain, right? Where exactly on that piece of terrain am I meant to create a border, right, to separate Scotland and England? Now, when you start looking at the world in this way, you realize that all of these borders that we've created are totally artificial. What the border that separates Germany and France is artificial. What separates Russia and Georgia is artificial. Morocco and Algeria is artificial, right? All of these borders are totally artificial. At some point, us as human beings have decided that this is going to be the territory of these people, and this is going to be the territory of these people. And what's remarkable is naturally, or in the physical world, this stuff doesn't exist. Everything that we've created exists up here in our minds. If tomorrow the people of Scotland, the people of England forgot what Scotland and England was, we forgot what a border was, we just eventually start to amalgamate into each other. We'd start to integrate into each other, right? There is no border. And so all of these are human creations. And I think that's the best starting point to then go on with your study of international law. A quick note about domestic law. Now, it seems obvious, right? It seems obvious that international is something exotic, something that exists with the whole planet, and domestic law is kind of just within one territory. Well, that is true to an extent, but it's not a very good explanation, right? So the best way to explain this, to explain domestic law, is that each state takes control of its territory, and in order to take control, it creates a domestic legal system which suits the morals and values of its people. So essentially what this means is that the Moroccan people are able to choose laws which suit the morals and values of Morocco, of the Moroccan people. And so this is a good way of looking at domestic law. And what's really interesting about domestic law is these institutions have often existed for centuries. Now, that's not the case with every country, right? So you have a lot of newly independent countries. Let's take, for example, Pakistan, right? It was given independence in 1948. that's not a very long time. That's less than 100 years that it's been independent. So its domestic institutions, its legal and political institutions are very young, right? They have not existed for centuries. You take the UK, for example, its institutions have existed for a long, long time. And so it's been refined over and over and over again. And now it's really, really solid. And that's what you'll find with a lot of the European countries, right? And then comparing that to international law, people think that international law has been around for a long time. It hasn't. It's a very, very new concept. Now, it's easy to overlook just how, I guess you could say, lawless states were when they used to interact with each other. And a perfect example of this is World War II. There was very, very little authority in international law and international regulation. So states often would violate laws and do pretty much what they want. So a lot of international law is very young. It's we will speak about this in the next lecture, but it's only really come about after World War II. And so the institutions have not been around for as long. So why do we have international law? Well, a lot of people, it's heavily criticized, right? Why, if we've got these domestic legal systems, do we need international law, right? Why do we need these states to start working with each other? Why can't these states just govern themselves? Well, there's a few reasons that you may need international law, right? Or that international law exists. The first one is exploration. So having an international legal system often allows people the freedom to navigate the world. Now, importantly, the freedom to navigate without being subject to restrictions and able to navigate safely. If I'm going to pass through someone's territory, I need to know that I feel safe by these international laws and that I won't just get murdered, or if I'm on a ship and it's going through someone else's territory, someone else's seas, I need to know that no one's going to come and arrest me. It's very important for exploration. For trade, it's almost essential. And actually, this is one of the fundamental reasons for international cooperation in the first place. If you want to provide essential services to others, right? So say you have this groundbreaking medicine that will cure malaria that's been developed in Germany, yet in Germany, there's very, very few cases of malaria. Well, it would make a lot of sense for that medicine to be traded for profit to countries, for example, in Africa, where malaria is still a huge, huge problem. So it's essential for trade, right? And of course, that does mean a lot of people get very, very rich. And then that does mean that they often exploit that for power. However, at least it's my opinion, that international trade and international cooperation has made our world a much better place. Like I said, human cooperation, right? We have international law for humans to cooperate and solve these global problems like poverty and disease, right? Things that us as human beings with a conscience shouldn't allow for other human beings to experience, right? And so the best way to solve these problems is to have all the minds working together. And last but not least, conflict prevention, right? Having international law establishes a type of legal order that prevents people from going to war with each other. Now, domestic law has this, right? It establishes government, and government is able to provide law and order in order to stop people from fighting each other, right? Whether it's groups, whether it's people, doesn't matter. International law needs pretty much the same thing. Now, the problem is when a country goes to war with another country, the effects of this in terms of destruction to life are much, much greater than if a person was just to murder another person. The only victim there really is the person who's murdered. When a country goes to war with another country, bombs start to fly around, there's biological and chemical weapons involved, there's armed militia groups, there's heavy duty machinery, and so there are civilians caught in the crossfire and a bunch of human rights abuses, and people can die and have an awful life afterwards as well. So it's very, very important to stop conflict. Now, a quick note about public versus private international law, right? There are two types of international law. There's public and private. Now, I'm going to have a very brief description of both of them, and we'll look at which one we're going to study in this course. So, private international law regulates the conducts of individuals when this involves more than one country. The best way of thinking about this is, for example, if I'm a business and I am creating a contract with another business in another country. So if I'm situated in Scotland and I contract with someone in Nigeria, this would be regulated by private international law because it's within private law, but with an international aspect. What this course will cover is not this, but public international law. This is regulating the conduct and relations between different states, right? So private individual law, private international law, it's people contracting with each other. Public international law, it's countries acting with each other or cooperating with each other or conducting relations with each other. And if you're interested, there's an excellent book called International Law by Jan Klabers, which I read at university, which I've used as my source material for much of this course. I believe now there's an updated version. So this was back in 2013. I believe there's an updated version now, so you can check that out. Excellent book. Hello and welcome back to this Introduction to International Law online course. So in this lecture, we're going to be talking about history, right? The history of international law and how it's got to where it is today. It's going to be very brief, and really you'll see just how young it is. So history, how did international law develop? So you'll find that with international law, it's a very, very young area, right? There's not been any solid or codified law, which goes back up until the 12th century or 13th century. It is fairly new. So here's a timeline of international law and what we'll be covering in this lecture. We'll be looking at the 17th century and the teachings of Hugo Grotius and the conclusion of the Peace of Westphalia, and that ended the 30 Years' War. And we'll be looking then at the 19th century, the late 19th century, and the first meetings of the Hague Convention. Looking at the early 20th century, which is the creation of the League of Nations. And then really where international law begins to take off is after World War II. So 1945 and beyond, World War II ends and all the post-war developments in international law start to take shape. And that really was a landmark in international law in terms of developing and codifying more law between states. So let's look at the 17th century. The two main developments that we see were, first of all, this man, Hugo Grotius. He wrote a book or an essay, I believe it was. It was called The Law of War and Peace, published in 1625. And Grotius was a leading Dutch intellectual at the time. And what he wrote in this book was that he introduced the concept of laws and regulations govern different states, right? So before that, people thought that there was no law governing two countries, two states. But he kind of changed this and realized that really people from different countries were beginning to interact with each other, beginning to trade with each other. And so therefore their governments must also be beginning to interact with each other. And so if they begin to interact, this requires new rules, new regulations. What he also did, he developed the concept of the freedom of the seas or the high seas. And that is basically the idea that when human beings are on seas, those seas are not the territory of any one country. So no one country can forbid human being going out on a boat and going to the Atlantic Ocean. So he developed the concept of freedom of the seas. The second main development that we saw was the Peace of Westphalia, and that was concluded in 1648. Now, this was a peace treaty that was concluded between different European countries, and it brought an end to the 30 Years' War. And the 30 Years' War was essentially a religious war between different European countries in which, there was a lot of bloodshed, a lot of fighting. And so this peace treaty, what it did was it divided different territories into nation states, right? And that's essentially where you get the creation of a lot of the European countries, such as Germany and France. The Peace of Westphalia developed this concept of a nation state, that people in Germany would be able to control people and set the laws and regulations for whatever was in its territory, and the people with France would be able to do so as well. But the main thing was that religions, right? Germany was able to decide its own religion, and France was able to decide its own religion, whether that be Protestant, Catholic, whatever, right? They would be able to decide their own. And so that would stop people from fighting each other. Moving on, international law then took another momentous leap during the Hague Conventions of 1899 and 1901. And what this did was it codified many of the international legal rules. So before these conventions, states were beginning to interact with each other a lot. And when they did this, there would be kind of law that was created between them. But most importantly, it wasn't written, so it wasn't codified. It was kind of like what we would call custom. So Germany knew how to act with France, but they never ever officially agreed on anything or wrote anything on paper. But they kind of knew how to act, and they acted in a way that assumed that they were bound by some sort of law. So the Hague Conventions brought together all these different countries and codified a lot of the basic laws that they were already bound by. And so, for example, in 1899, one of these sort of codifications, an example would be the Declaration concerning the use or concerning the prohibition of the use of projectiles with the sole object to spread asphyxiating poisonous gases, essentially biological and chemical weapons, right? Even back then, people knew that whether in war or in peacetime, you cannot attack people with biological or chemical weapons. Then in 1907, there was another conference. An example of what they concluded there was the convention relative to the rights and duties of neutral powers and persons in case of war on land. Essentially, that a independent or neutral country cannot be attacked during war, right? And there was a bunch of these different laws and rules, and it was very, very important for the codification of international law and making international law this subject that you're able to study. The League of Nations then was created, and this was in the early 20th century. And what the League of Nations did is that it was essentially the first intergovernmental organization. So whereas with the Hague Conventions, this was a conference, kind of like a convention where different countries would come and they would sign a few documents and a few treaties and go back home. In the League of Nations, they created an actual organization. So now, instead of just signing a few documents and going back home, states agreed to be bound by whatever rules this organization created. The League of Nations no longer exists. It was succeeded by the UN, and it essentially disintegrated because of a number of reasons, which I'll go through. People often think that the League of Nations was a complete failure. It wasn't actually. It prevented a lot of things. So some of the benefits or the advantages of the League of Nations was that it created the first world court. It was called the Permanent Court of International Justice. So today, the World Court, I guess you could say, is the International Court of Justice. Well, its predecessor was the PCIJ, right? And so this was revolutionary. The idea that you had this world court that would decide cases between different countries. That was a revolutionary idea at the time. What it also did, it also prevented some minor conflicts. So an example would be the German-Polish conflict over Upper Silesia, which was a disputed territory between the two countries. Now, what's so important about this is that a lot of the time, big conflicts will emerge from the minor conflicts, from small things, right? Even World War I and World War II, right? I read a book which sort of described how people at the time felt about World War I and World War II. And you would think that people knew that something historical or momentous was happening in the world, that this was a big war. It was only after the fact that people reflected on the war, that they realized just how drastic, just how big an effect it had on human history, right? At the time, or during the early stages of the war, people just thought it was a minor conflict, a minor skirmish that would eventually evaporate, right? Eventually come to a halt. And so that's really important. It was really important for the League of Nations to prevent some of these minor conflicts in case they then began to escalate and become worse. So, you never know. That conflict between Germany and Poland about Upper Silesia could have gotten very, very ugly, and we could have had 3 world wars instead of 2. What the League of Nations also did was develop international law further. Like I said, the Hague Conventions codified a lot of laws. The League of Nations just added to this, and it became a much more studyable subject. Unfortunately, the League of Nations didn't last. There were a number of reasons for this, and you can roughly summarize it into a few, right? So, for example, sanctions. Normally when states break international law, the best way to punish them is actually not to declare war on them. It's to hit them with sanctions, economic sanctions, political sanctions, military sanctions. And today that's quite an effective remedy. But during 1910 or 1920, the sanctions that the League of Nations would impose were very, very ineffective, right? And the reason they were so ineffective was because there was no central decision-making authority. No one institution within the League of Nations had the power or ability or the respect or the authority to tell nations what to do or to kind of whip them in line. And so because of this lack of central authority, it couldn't prevent World War II from breaking out. Germany violated the League of Nations, it then went on to withdraw from the League of Nations, and which means it was no longer bound by any international laws and obligations. And so it was able to then become the catalyst really for World War II. After World War II, when people came to terms with the atrocities of what just happened and of many human rights abuses, people began to take more of an interest in international law. And so most of modern international law originates from these conventions and peace treaties and human rights treaties that were concluded after the war. So examples of these institutions would be the United Nations, the World Trade Organization, and GATT, which is very important because once you have countries that trade with each other, they're less likely to go to war with each other. The International Criminal Court, which is holding individual heads of state, so presidents and prime ministers, to account for human rights abuses and crimes against humanity and genocide. The European Union, which is super important, which has become this sort of all-encompassing international organization that trades, they decide social policies, they decide everything really. This was after World War II because that occurred within the European states. The ECHR, which protects individual human rights as well. Now, two cases that I really want to look at, which are actually very, very important for understanding some basic principles about international law, is first of all, the SS Wimbledon case, which was in 1921, and second of all, the Lotus case in 1926. And the facts aren't as important as are the general rules that these two cases created. So that was that international law is a consent-based system in which, in order to be bound by it, a state must be sovereign, right? So it must have control of its own territory, it must be independent, and it also has to consent to being governed by international law. A state cannot be bound by international law automatically like a citizen of Scotland is. As soon as I am born in Scotland, I am automatically bound by the laws and regulations of that country. States, on the other hand, countries, they're not automatically subject to international laws. They have to consent to being governed by this. Now, the good thing is in modern international law, it's often very beneficial for states to be bound by international law, right? That's why there are so many members of the UN. It's often much more beneficial for them to have a voice in the General Assembly, to be protected by the UN Charter, to avoid other bigger countries coming and invading them, and to be able to trade freely. So it's much better for them. But this is one of the main aspects of international law that you'll need to bear in mind. Welcome back. We're on to lecture 3 of Introduction to International Law. Now, here is where we really get into the nitty-gritty, right? We really get into the law of international law, and we're going to look at legal concepts, and we're going to look at the operation systems of the legal nature of international law. Where does international law come from? Now, I think it's really important to note that international law is not as codified as domestic legal systems. And what that means is that there is no set document or official document which states exactly the different sources of law. The closest thing international law has to sort of like a document that states the different sources of law, it's this. It's the Statute of the International Court of Justice, the ICJ, which is the UN's world court, the UN's own court which decides disputes between states. And it's contained in Article 38, subsection 1. So the statute of the ICJ is regarded as very good authority for understanding what sources of law are in international law. However, it's not official in the sense that these are the only sources of law. I'm going to look at this in the later slides and look at how there may be other types of sources of law that could be applicable in international law, perhaps in the future. But for now, this is a really, really good foundation, the statute of the ICJ, Article 38. So, what does it say? Well, the court, which is the ICJ court, whose function it is to decide in accordance with international law such disputes as are submitted to it, shall apply first international conventions, then international custom, then the general principles of law recognized by civilized nations, and then judicial decisions and the teachings of the most highly qualified publicists as subsidiary means. Now, those are the most important areas we're going to look at. So essentially what this says is if you were to rank these sources of law according to the ICJ, that international conventions and international custom share the #1 spot. They have pretty much just as much authority as each other. There may be the only edge that international conventions have over custom is that it's codified, it's written down. And so you don't need to guess, it's much more robust, you can tell where the law is. But in reality, they are very, very high authoritative sources. Now, a lot of commentators have noted that the third source, which is general principles of law, is often used only to fill gaps, right? It's not to be used as the sole authority for international law, right? Just because general principles of law is, as the name suggests, a very general area. What is a general principle of law? And general principles differ between different domestic states. And so they may not all agree on this, whereas with international conventions and customs, the idea is that they essentially are all bound by it. They all agree with it. Finally, as a subsidiary means only we're going to look at judicial decisions and publicist teachings. Subsidiary meaning that you only use these to back up your argument and not to use them as a sole source of law to decide a case. Let's now begin to look at international conventions and treaties. Okay, so international conventions and treaties. Now, in the statute, it states international conventions. I've added treaties. Really, in reality, a convention or a treaty is just a document on a piece of paper signed by different countries with a bunch of different laws, right? So you have Article 1, blah, 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 Article 2, blah, blah, blah. And they can take different forms. You can call them a convention, you can call them a treaty, a declaration, an agreement, it doesn't matter. But essentially they serve the same purpose. It's some sort of agreement between countries or declaration between countries that they agree to be bound by this law. It's often the dominant source of law just because, like I said, it is essentially custom except codified, right? It's written, it's easy to read, it's easy to study, and people will look at it as a very, very good source of law. Treaties themselves are governed by another treaty, right? So the Vienna Convention on the Law of Treaties. So it's almost like a double glazed window, right? In order for there to be rules on treaties, countries need to agree on those rules on treaties. How do you come up with an agreement on the rules on treaties? Well, you make a treaty. But those are to do with very, very technical specificities about treaties, right? What's a reservation? When can a country sign? How can it sign? These things like this. What's also important within treaties is that, as stated in the VCLT 1969, every single state who enters into an agreement or a convention or a treaty must apply principles of good faith. That is, they go into the treaty acting to uphold the treaty and uphold the laws and regulations of international law. So act in good faith. And they have to act with consent, right? No one can force them to be part of this treaty. They must do it out of their own volition. Secondly, we get on to custom, international custom. Now, custom can be very, very difficult to understand, especially for non-lawyers, right? It took me 4 or 5 years to really get to grips with custom. But I explained this in my Introduction to Scottish Law course, and Scottish law also has custom as a source of law. And I'll try and explain this how I did back then. Imagine me and a friend have a custom between us that every time we meet up, we shake each other's hand, right? So every time I was to meet this friend, I would shake his hand. And this would continue for 10, 20, 30 years, that every time, literally every time I'd meet him, I'd shake his hand. Let's say one day, right, after these 10, 20, 30, 40, 50, 100, 150, 200 years of me shaking his hand every time we met up, he decides not to shake my hand. My initial reaction would be, well, what the hell, right? Why are you not shaking my hand? It's almost as if we've created a law, and then by him not shaking my hand, he's broken that law, right? Now, you wouldn't normally think of law in this way, but that's exactly what it is. Now, imagine that it's not me and him shaking each other's hands. Imagine this is issues in society, right? Crime and murder and contracts and family law and property, etc. These are all just customs that have now been written down and codified, right? And so international law, like I said, it's such a new area of law that not all laws are codified, not all laws are written down. Some of it you have to rely on custom. And so whereas in domestic systems, almost all custom is now written down in law somewhere, in international law, it's not always written down because there's so many problems. You need a lot of states to agree. You can only be bound by it if you consent, etc. And so custom plays a huge role in international law. Now, whether that will continue to exist in 1,000 years, I'm not sure, right? I don't think so. I think by that time, international law will be much better established. The institutions will be much stronger. And so you won't need to rely just on basic custom. But for now, it's very new and we do have to rely on it. So there are two things, if you remember in the ICJ article, that you require for custom to be accepted. The first thing is it requires a general practice between states. So a lot of commentators have found that what a general practice is any material or legislative acts of state. So a material act of state could be anything a state does, right? Any sort of actions that it does that are regarded as law. And any legislative acts are the legislation that it adopts in its domestic law. So let me give you an example of a material act of state, which could be regarded as international custom. Let's say states, whenever goods enter their country, they have to carry out the relevant checks to make sure those goods are safe and sanitary. Them carrying out those checks on those goods would be regarded as a material act of state. A legislative act of state would be if that country provides a law or passes a law stating that any goods that come in have to be safe and sanitary and they'll be subject to checks at the border. And that would be regarded as general practice. Now, on top of general practice, you also need any general practice that is also accepted as law. Now, the way you measure this is through this thing called opinio juris. So there are a lot of acts of states, or a lot of acts that governments do, which they do often, but they don't regard it as law. So let's say, for example, rolling out the red carpet for foreign diplomats to come in. Now, that's a very, very important custom. It's a general practice. It's a material act, but neither the state who steps onto that red carpet nor the one that rolls it out regards this as being bound by law, right? That would just be silly. So there's got to be some things where people feel that they must be bound by law. And so this idea of opinio juris essentially is the idea that a state feels subjectively bound by a law, right? What do states feel? Do states feel that they're bound by this law? Well, if they are, then that means it's accepted as law. If there's a dispute and if they don't feel that they're bound by law, well, then it doesn't satisfy one of the criteria for custom, and therefore, most likely, it won't be international custom. Next, we look at general principles of law. Now, like I said, it's not as authoritative as the other areas of law I looked at before. So with general principles of law, they're often just used to fill the gaps between international custom and international conventions. Because international is so new, so international conventions won't be able to regulate on every type of issue, and there might not be custom on every type of issue either. This is where you look at some of the general principles of law. In Article 38 of the statute, it stated that only the civilized nations as general principles of law are regarded. Now, this distinction today is very unclear. The roots and history of this distinction between civilized and uncivilized nations was back when countries were still ruled by colonial countries, right? So whereas the UK would be kind of classed as a civilized country, it was governing over, let's say, India, right, as an uncivilized country. Now, of course, today that distinction is problematic. It's almost termed racist. So today, new distinctions might have to be made. Maybe this could be democratic and undemocratic countries, but again, that poses more problems about, well, is this country democratic? Is Turkey a democracy, right? And so there's problems when it comes to this stuff as well. And so it's likely that this will be subject to amendment perhaps in the next few years. And there are numerous general principles that are covered. For example, we have the double jeopardy rule, where no one person may be tried twice for the same crime. Or let's say, for example, ignorance of the law is no defense to an act. So if you commit a crime and you say that I wasn't aware that this was a crime under law, then that's no defense. There are a number of different principles that you can apply. And finally, we look at subsidiary law, that is judicial decisions and institutional teachings. Now, first, we look at judicial decisions. In my introduction to Scottish law, I spoke about judicial precedent, which is very, very important in the British legal system and in common law legal systems. Essentially, judicial precedent is the idea that judges are able to replace and make law themselves, instead of it only being in the hands of government, right? So if I'm a judge, I can give a law or my opinion, and that then becomes law, right? Instead of it just becoming merely persuasive. International law doesn't operate on this system. It has no idea of precedent. And so any decisions from the ICJ or any other court will not bind future decisions, right? It won't then become law. The only law would be what we've discussed: conventions, custom, general principles, right? The other form as a subsidiary means would be publicist teachings. And this would be, for example, Hugo Grotius that we spoke about in the second lecture, sorry. So Grotius's teachings would be regarded as publicist teachings. He's a very intelligent philosopher. He's an institutional writer. And any of his books and essays would be regarded as relating to international law and establishing some very, very well-founded principles. And often the publicists will relate to international law. Now, I said earlier how there may be other possible sources of law outside of the five that we've just mentioned. So that'd be customs, treaties, general principles, and the subsidiary means, right? There's a lot of discussion between academics about whether there are other possible sources of law, with three main ones being the most commonly discussed, right? So the first one would be UN resolutions. Now, UN resolutions are the result of a consensus, a broad majority consensus of all the official states in the world, around 194 of them. The second type of possible sources of law are articles by the International Law Commission. Now, if you don't know the International Law Commission, it's essentially an organization of leading international law academics, and they put their minds together and they create those big conventions and treaties that countries then follow. So an example would be the Genocide Convention. That was essentially created by the ILC. And the ILC are now looking at more conventions, creating more conventions. So an example would be they're creating a convention regulating crimes against humanity. And so the ILC are these incredibly, incredibly intelligent academics who sort of all come together and create these very, very detailed international treaties and conventions. It's possible that in the future, their articles that they submit, so either their draft articles and things like this, could become a source of law in themselves. And last but not least, unilateral declarations. Now, unilateral declarations could be any sort of statements or, like I said, legislative acts or anything that they've said or done, which can then be regarded as being a declaration from that country. So the idea is that if enough countries come out and say something, eventually people will be bound by this law. So if tomorrow the USA comes out and says that the sky is green, and suddenly Bolivia and Venezuela and Germany and France and Kenya and Zimbabwe start to agree that actually, yeah, the sky is green. If 194 states start to make declarations that the sky is green, eventually the idea is that this will just become a part of international law, that the sky is green. Now, of course, that's not always the case. And a lot of the time, if a state makes unilateral declarations, this could be regarded as maybe a material act of state. And if they feel that heavily about it, they'll normally put it into legislation anyway. And so it would then become a legislative act of state. And so then it would be an example of general practice. And if it's an example of general practice, all you need is that it's accepted as law. Then it becomes international custom. So it's a source of law anyway. But it's an interesting roundabout way of saying what could be regarded as law in future. Hello, welcome back. We're on to lecture 4 of this Introduction to International Law online course. And in this lecture, we're going to be looking at dispute settlements, right? Essentially, who decides the cases? So it's obvious that if you have laws and regulations that apply to countries, apply to states, well, there's obviously going to be disputes. And so who is the one that actually decides them? Well, we have a number of ways that we can do this. And we'll be looking at very specific legal methods. In international dispute settlement, you can either go through the political/diplomatic way, or you can go through the legal way. Political and diplomatic ways we're not going to cover, but some examples are negotiation, mediation, conciliation. There are others as well, such as inquiry and fact-finding and other kinds of ways to politically and diplomatically come to a dispute, come to an agreement on a dispute. And the advantages of these compared to the legal methods is that often when it's political and diplomatic, it's often just two states getting into a room and agreeing with each other on an issue, or maybe talking it out, essentially. It's much quicker, much, much cheaper. There's no need for lawyers or cite the law or anything like this. And so things get resolved much quicker. And often this is what states will do, just because it's much easier. Now, if the states are not able to diplomatically make amends or settle their issues, they can then use legal methods. We'll be looking at two of them. First is arbitration, and the other one is adjudication, aka litigation or court action. We'll be looking at the differences between them and exactly who will decide each case. Before we begin, I want you to take a very good mental note of this place. It's called the Peace Palace. It's located in The Hague in the Netherlands. This building will host both of the courts that we're going to discuss in this presentation. That is the Permanent Court of Arbitration and the International Court of Justice. Now, the idea is that there isn't a separate room for the ICJ and a separate room for the PCA. The idea is it's the same room, except they'll change the layout and they'll change the name. But this Peace Palace will hold all of these disputes and all of these cases. Very interesting place. I'm sure you can go and visit it if you are ever in the Netherlands. So let's begin with arbitration. So what is arbitration? Well, arbitration is when two parties in a dispute will submit their arguments and evidence to a trusted third party to make a decision. Now you might be thinking, well, how is that any different from court action, from adjudication? Well, there are a few differences between that and arbitration. So if you compare that with litigation, there's no use of an official judge or court, right? So you don't need a judge who's had 18,000 years of experience, right? It can be anyone. An arbitrator can be anyone. Often it's decided by the two parties. So a really, really normal case or a really common case in international law is, let's say Germany and France are in a dispute with each other and they take their case to arbitration. Both of them will then probably pick an arbitrator to decide, aka a neutral country. Let's say that could be Portugal, or let's say it could be Spain, right? Or it could be the United Nations General Secretary, who is, by this definition, is meant to be neutral. So they can basically pick. So that's not the same with the judge. The judge is often not selected by the parties themselves, it's appointed. It can also be conducted without lawyers if they would like, right? So often there are legal arguments, but it can be conducted without lawyers. And the decision that arises from an arbitration is confidential and private. That means cases aren't as public and the decisions are often kept between the parties. And the benefits of arbitration over court action, well, it can be quicker, it can also be cheaper, and it's often much more informal. Parties will often adopt this measure, and there's a bunch of arbitration cases every year. And the most famous court of arbitration, now that's a misleading title because technically arbitration chambers are not courts. It's not technically a court because it's not a legal court. It doesn't submit legal proceedings, but it's called the Permanent Court of Arbitration. Should really be called Permanent Chamber, the Permanent Institution of Arbitration. But this is located in the Peace Palace again in the Hague. It was created in 1899. And it consists of appointed arbitrators from each of the parties. So often, say, let's say Germany, it will appoint a preset list of arbitrators that if it were to ever come into court action, it knows who is going to decide those cases. And it's not just states that can bring cases here, it's non-states. So for example, companies and businesses, international organizations like environmental organizations, so they can bring cases to the PCA as well. Some notable cases now, bearing in mind arbitration cases are not public, right? They're often confidential. It's difficult to find notable cases. It's difficult to find cases that are fun to actually read, right? But I found two which were historically pretty interesting. So the first one is the case of the island of Palmas. It was Netherlands against the USA. And in this case, the dispute was over this island in the picture. It was the island of Palmas, which is now located in Indonesia. And it was decided that this was the territory of the Netherlands and not the USA. And the arbitrator in this was Max Huber, who was an international arbitrator who decided on a bunch of different cases. Another specific case, which was interesting, was during the Eritrean-Ethiopian War. Both the countries decided to submit their claims to the PCA over the disputed territory of Badme. Okay, and then that got eventually resolved. So the second legal method that states can use is adjudication. This is just basically normal court action. So using a court or a similar institution such as a tribunal to settle a dispute. We're very similar with courts and how formal, how rigid they are. You need to hire lawyers and evidence, and it costs a lot of money. There are around 125 different international courts and tribunals across the world. Now, the reason there's so many is because there's actually loads and loads of international organizations There's one statistic stating that there are more international organizations than there are actual states. So the UN will have 194 countries in it. The UN itself is an organization, but along with that, all these little states have their own mini organizations, right? Some are bigger than others. For example, the EU is bigger than the Arab League, for example, but they all have their wee mini organizations. So with each of these organizations, they have their own courts and tribunals. And so there are around 125 different international courts and tribunals. Not all of them take on a lot of cases. Some take on 0 cases every year, right? The ones that are the most important are, for example, the European Court of Human Rights. They take on a lot of cases. The International Criminal Court, the ECJ, which is the EU court, the International Tribunal for the Law of the Sea, which takes on cases regarding the law of the sea, on disputes regarding natural resources and seas and oceans and stuff like that. And the African Court of Justice, which is a court that deals with African states, African parties. And of course, the most important international court in the world, over and above what we just saw in those examples, is the International Court of Justice. Now, there are 2 reasons why it's the most important. Is the ICJ has jurisdiction, A, over the most number of people in the world, because there are 194. So the UN as an organization has the most number of states as members in the world, right? The EU only has 26 states and the UN has 194. So that means that every single person pretty much in the world is subject to the law of the ICJ, because all 194 countries are under its law. Theoretically, the ICJ has jurisdiction over the largest number of people around the world, upwards of 6 billion if you live on a territory. No other court has that much jurisdiction. But also, what is also important is that the ICJ, theoretically again, can decide on any subject at once, whether that's use of force or international law of the sea or environmental issues or contract issues, whatever it wants, right? As long as it has some sort of international perspective. Whereas the courts we looked at before, let's say the European Court of Human Rights, it's limited to only analyzing cases which are the basis of human rights, right? It can only look at human rights cases. Look at International Tribunal for the Law of the Sea. It can only look at cases regarding the law of the sea. International Criminal Court, it can only look at criminal acts. The ICJ can look at pretty much all of them plus. That's why it's so important in the world. Created in 1945, again, that's after World War II. It consists of 15 ICJ judges. So you often see them in a big row, and each ICJ judge will be there, right? They're Supreme Court justices. In my previous course in Introduction to Scottish Law, I looked at the UK Supreme Court. And in the UK Supreme Court, I believe there are 13 Supreme Court justices, 12 or 13, I'm not entirely sure. So there's either 12 or 13 Supreme Court justices. And I described those UK Supreme Court justices as, if you're making a football analogy, as the Premier League of judges. They are some of the smartest people in the country, right? They are in the top league of law, of judges in that country. If you look at the ICJ, these 15 ICJ judges, one of the requirements for being an ICJ judge is that you have to have had qualified at the highest level of your domestic institution in order to just be considered as an ICJ judge. So if you look at the UK Supreme Court as the Premier League, ICJ judges are like the World Cup of judges. And not even just the World Cup, because in the World Cup, you've got teams who are not very good who compete in that tournament. You'd probably say like the quarterfinals and above of the World Cup. So really the best of the best. And what's important is with ICJ, only states can bring cases. So no environmental groups, no businesses, no companies, only countries. And there are so many notable cases because the cases are so public and they've had a huge effect on international relations, right? So one of the really important ones was about nuclear weapons. It was an advisory opinion. And they said that the possession of nuclear weapons is not strictly prohibited in international law, but this must be used in self-defense. And this was a heavily criticized decision of the ICJ because essentially they were allowing for the use, whether it's a sole use or not, they were allowing for the sole use of nuclear weapons. And as we know, you only need one use of nuclear weapons in order to pretty much wipe out humanity. Because what happens is if one country says that they're using nuclear weapons in self-defense, another will use it in self-defense, and it will just keep going, and eventually you have the end of humanity, right? You'll wipe out 90% of the population and the flora and the fauna on Earth. And then what use is international law then, if we have no one to be subject to it, if we have no people? So it's a hugely criticized opinion, but they have to look within politics. They have to work, the ICJ have to work within the political atmosphere at the time. And so if they were to come out and strictly prohibit nuclear weapons, it would have angered a lot of the nuke-producing states at the time. Another interesting case was Nicaragua against the USA, where the ICJ stated that the USA violated international law by supporting a Nicaraguan rebel group to fight against the Nicaraguan government, which basically means that by proxy, the USA was guilty of aiding the overthrow of the Nicaraguan government, right? So you're attributing state liability for the actions of someone else, which is very interesting. And the USA funded this rebel group loads. I think it was the Contras. They funded the Contras like crazy. Interesting case again, Israeli wall advisory opinion. So this picture you can see is the wall that separates Israel and the West Bank. And the ICJ ruled that the barrier separating Israel and Palestinian territories is a violation of international law. And this wall is unfortunately still up, and it's the source of a lot of contention in Palestine and in Israel. Even recently, it was still the case. And there's been a lot of new UN resolutions. There's been an ICJ case to say that this is illegal, but unfortunately, very little has been done about this, mostly again due to politics and due to power struggles between countries. And what's a recent ongoing case that's come to light to the ICJ is the Rohingya Genocide case. So this is ongoing, and this is deciding whether Myanmar, the state of Myanmar, also known as Burma, has committed a genocide against the Rohingya ethnic group, which are in its territory. And both parties are submitting claims. It's actually Gambia that has brought the case against Myanmar to the ICJ. And so it would be Gambia that provides all the evidence. So they'll be providing the evidence, and this will be ongoing. I'm sure it'll take a while for the ICJ to make its decision. It should be interesting as to what happens in the end. Hello, welcome back. We're on to lecture number 5. We're so close to the end now. Only one more lecture after this. And in this lecture, we'll be looking at jurisdiction. Now, it sounds very, very boring, right? What actually is jurisdiction? It's basically, how do you decide who applies the law? Now, normally, this can be a very boring subject. It can be a very boring topic. And I'm actually very proud at how I've laid out my slides and how I've tried to explain this concept in a very easy to understand fashion, right? So I'm hopefully, through this lecture, going to explain the basics of jurisdiction, of international jurisdiction, what state gets to apply what law, and who decides who applies the law. And hopefully doing that, I'll be able to enlighten most of you. As a note of caution, I would say try and make sure you pay attention to this lecture, because if you do, that concept of jurisdiction will just become really, really easy for you to understand. So make sure you pay attention. And if you need to go over it once or twice this lecture, then feel free to do so. So I'm going to begin first by saying that theoretically, every inch of planet Earth is subject to law of some kind. And what I mean by that is, it doesn't matter if you're in the city, doesn't matter if you're in the ocean, if you're on the Sahara Desert, or if you're in the Amazon rainforest, right? As long as you're in the orbit of planet Earth, it is someone's job to apply the law that has come from somewhere. At least theoretically, that's the idea. Now, obviously, if you were in the Amazon rainforest and let's say you robbed someone and ran away, it's very, very hard for someone to actually prosecute you because there are a lot of practical considerations I need to take into account. How are the police going to get all the way into the Amazon? How are they going to identify you? There are no witnesses, right? So you need to take these things into account. But theoretically, you are subject to the law of presumably Brazil if you're in the Amazon, but in any forest, there'll be some country whose job it is to prosecute you. Now, the problem comes where two states start to argue about whose job it is to prosecute, whose job it is to apply the law. And that's what we're going to look at. Now, just quickly, noting the freedom of the seas, right? Freedom of the high seas. When I talked last time that the high seas are free and no one state can rule over it, that doesn't mean that it's lawless, right? That doesn't mean that you can take a boat, go into the middle of the Atlantic Ocean and kill someone and you won't be prosecuted. What it does mean is that no one country has exclusive jurisdiction over prosecuting you. If you're on the Atlantic Ocean and the closest country is Belgium, let's say, for example, that doesn't mean that it's Belgium's job to put you into prison, right? It could be anyone, right? It could be the owner of the ship, or what country you're a national of, or what country the victim is a national of. That's what it means. It doesn't mean that it's totally lawless and you can do whatever you want. Now, in practice, that sometimes is the case, right? That crimes committed on the high seas are very, very rarely are they prosecuted by anyone, because normally states just don't know or don't care to find out whose job it is to prosecute. So eventually people do get away with it. But it's just something to bear in mind about jurisdiction. When you look at jurisdiction, you have to look at different types, right? So we have territorial, national, protection of national interests, passive personality, or universal. And each of these types of jurisdiction will be claimed by a country to state that we have jurisdiction to decide this case because of territorial, national interests. Our nationals are, they are passive personality, universal. And I'll be looking at each one of these in turn and using examples, and hopefully I can break down this sometimes difficult concept into really, really easy bite-sized information. So let's first look at territorial jurisdiction, which is easily the most common. This is where a state has a right to prosecute individuals for crimes which took place on its territory. So perfect example. Let's say we're in Germany and we have Alex here and he's got a gun and he shoots Anna. Well, who or which country is going to prosecute Alex for his crime? Well, in this case, it's pretty obvious. It's going to be Germany. It's Germany that has jurisdiction because the crime took place on German territory. It becomes complicated in the next example. What if now Alex is in Germany, right? He's standing on German territory. He shoots his gun, but the bullet lands in France and it hits Ella in France, right? What then? Who's to decide who prosecutes Alex now? Would it be Germany because he shot the gun there? Or would it be France since Ella received the bullet there? Well, what we would say here, because the bullet travels from Germany to France, what we would say here is that Germany claims jurisdiction based on the intention of the crime. So that would be the subjective intention. And then France claims jurisdiction based on the effect of the crime, objective effect. Both of these two countries have valid legal arguments to prosecute Alex. But what would normally happen here is France and Germany would get into a room, and like we discussed before about international dispute settlement, they'd come to a negotiation or an agreement as to who is going to prosecute Alex, right? Practically in this example, it's not a problem. German law is very, very similar to French law. Shooting someone is pretty much the same sentence or same crime. It gets a bit complicated when you have crimes that really do span loads of countries, right? Or if you have more than one country that a crime's been committed in, crimes such as fraud or cybercrime. These are really, really interesting international legal issues that smarter minds than me have struggled with. So that's territorial jurisdiction. And unfortunately, that's probably the most basic of jurisdictions, right? And even that's a bit difficult to comprehend. So now I'm going to go through the next four. The next one we're going to look at is nationality jurisdiction. And this is where a state has a right to prosecute individuals who are nationals of its country. So let's look at the example again. Let's say we're in France, right? And Alex, the guy from before, he's got a gun and he shoots Ella. Remember, right this time, he's not shot it from Germany, he shot it in France, the gun, right? But Alex is a German national. Normally, you'd think, okay, well, it's taking place on French territory, and so France has jurisdiction. Well, yes, unless Germany really, really, really wants to prosecute Alex themselves. Maybe Alex is a public figure, or maybe Alex is an enemy of the state, right? Maybe Germany really wants to prosecute Alex. It then has a valid claim to do so under nationality jurisdiction. So Germany would then claim jurisdiction based on nationality of the perpetrator. Now, yes, it contradicts territorial jurisdiction, but there are times that this is important. Maybe Germany does have a valid claim, right? Whatever it could be. The third type of jurisdiction we're going to look at is protection of national interests, right? Jurisdiction based on protection of national interest. And this is where a state has a right to prosecute individuals where it is in its national interests to do so, right? So again, we're in Germany, okay? Here's Pablo, okay? This time Pablo has the gun. We're in Germany. Pablo has the gun. And he is planning an attack to shoot possible French victims in France, okay? Now, the attack is planned in Germany, but it's to be carried out in France, right? Classic terrorist attack, right? Pablo is a terrorist. He's in a German basement. He's carrying out his attack on French soil, and eventually he gets caught, right? His victims is going to be France. The crime was going to take place in France. It was planned in Germany, and Pablo, which is interesting, is actually an Italian national. So we have all these different types of jurisdiction, all contradicting one another. And in this case, this is where France may claim jurisdiction based on the fact that it is in their national interest to do so. Remember, it can't rely on territorial jurisdiction because the crime of planning a terrorist attack took place in Germany. It can't rely on nationality jurisdiction because Pablo's an Italian national, but it can rely on its national interest. So the fact that there were these French victims that were going to die, France could then prosecute Pablo. The fourth type we're going to look at is passive personality. It's probably the second most controversial one, and I think it's very rarely used, but it's the idea that a state has a right to prosecute individuals where the victims were nationals of its country. So let's take that a similar example again, right? So we're in France now, and Alex, the German from before, he's got his gun, and he actually shoots and kills a bunch of Italian tourists, a bunch of Italian victims in France, right? In this case, territorial jurisdiction, France. Nationality jurisdiction, Germany. And national interest jurisdiction, well, I guess you could say that Italy has a claim for national interest jurisdiction because the victims were Italian. But what differs this from the previous example is that there was going to be a terrorist attack actually taking place on French territory. In this case, the Italians are actually in France, right? They're just Italian by nationality. Italy here that claims jurisdiction of passive personality because the victims of the attacks were all Italian nationals. Now, I can tell that this is getting a little bit confusing, and this is maybe where you want to go back and revise national interests and look at the difference between that and passive personality. The final form of jurisdiction, which is very, very different to all of the other ones that we've looked at, this thing called universal jurisdiction. It's probably the most controversial, but at the same time, very exciting form of jurisdiction. And it applies almost solely in international law. And this is where a state has the right to prosecute individuals where this is in the interests of humanity. An excellent example is, we're in France again. Here we have the French government, okay, and they kill a bunch of its own French citizens. This seems as if this is a totally French issue, right? It's a France issue here. French territory, French victims, French nationals, it doesn't matter. French national interests. This is a France issue, open and shut case. The problem is that because it's the French government that is shooting French victims, who exactly is going to prosecute the French government? Would it be the French government itself? Well, no. Would it be the French courts? Well, it's highly likely that the courts have been paid off by the government, or there's some corruption, or the courts are basically a mouthpiece of the government. Would it be the other French people? Well, probably not. They don't have official legal capacity to try the French government. So who exactly is going to prosecute France for killing its own people? Well, Germany has no connection to the crime, but Germany claims jurisdiction based on the fact that it is in the interests of humanity. And this is what is so controversial about universal jurisdiction. What gives Germany the right to interfere with internal French politics or internal French matters? And this is the biggest criticism of universal jurisdiction. It basically may give powerful states the right to interfere in other countries and their internal regulations, laws and regulations. But the flip side, from a more moral point of view, from a moral perspective, is that it is absolutely necessary, because we have cases of crimes against humanity and genocide occurring, and this has occurred through generations, through centuries, and no one has been able to prosecute until very, very recently in human history. And one of the best examples I can give of an organization who uses universal jurisdiction is the International Criminal Court, the ICC. To just give you a framework for just how remarkable the ICC and its application of universal jurisdiction is, it is assembled by 123 countries. That's the ICC. It's located in the Netherlands. It has a Nigerian president, a Gambian prosecutor. It once investigated Venezuela upon the request of Argentina. In no other point in human history has there been this much cooperation between this many different people to prosecute a very small elite group. It really does give you a sense of the power of UJ, the power of international law, and how slowly this world that we call planet Earth, divided up into 200 states and thousands of different cultures, has managed to become this one global community. From my opinion, regardless of what's been going on with nationalism and politics, and the ICC's come under a lot of criticism, I think in the future this is probably something that will remain, especially as international law becomes more and more prominent. Hello, welcome back. And here we are at the final lecture on this Introduction to International Law online course. I've had a great time teaching, making this course. It's been great. But in this last lecture, we're going to be discussing some problems in international law and try and get you guys to start thinking about, well, what is the future of international law? And if I ever do practice in it, if I ever do work in this area, what kind of things do I need to deal with? So here are some issues that I've identified when it comes to some challenges that international law is going to face, right? So the first challenge that I've identified is one that's very, very common to international law, maybe just law in general, and it's politics. It's the interference of politics and different political opinions and theories starting to mess around with international legal concepts, okay? The second area that I've identified is the rise of nationalism, again, very closely linked to politics, but this idea that states are becoming more introverted, starting to become more national instead of becoming more extroverted and looking towards the wider community. Another area that has always really been a problem with international law is the idea of enforcement, right? So the idea that you have a police force in a domestic state that enforces the law, but in international law, you don't actually have this. You don't have an international police. So we're looking at enforcement and what kind of problems that causes international lawyers, especially. And the fourth area, technology, right? It's going to impact pretty much every industry, I think, existing. And it definitely is going to impact law. Already, technology is beginning to impact some legal firms in domestic countries. And it's only a matter of time before international law also faces the technological wrath. Let's begin first by talking about politics, the importance of its role in international law. Now, when you take a domestic state, any sort of country, right? It's obvious that the political theories, the laws and values, the political values that country's people hold will be illuminated in the law of that country. Let's take, for example, the USA and Russia, right? If we take Russia as a country where communism and socialism is the dominant political view, or it was, if you take the Soviet Union, that was the dominant political view, its laws are going to reflect that. It's going to reflect a socialist and Marxist view. And in America, where it's much more free market, it's about free market capitalism and liberalism, its laws are going to reflect that political view. So it's obvious that you can never, ever draw a line between politics and law. They are heavily, heavily influenced, and they both influence each other. It's obvious then that if you get international law as its own system of law, that the politics and the political views of the individual states is also going to begin to influence international law. And this is where you get different theories about international law, whether it takes one particular view or whether it takes another particular view. But the problem with international law is it's not made up of sort of this collective group of people. It's made up of political values of 200 states, all with different views on the world, all with different views on how to make the world really a better place. And so what you'll then have is that international law is interpreted based on a wide variety of different areas. So for example, you have a colonial interpretation of international law, that international law is used to further the powers of former colonial countries. You have, at the same spectrum, you have anti-colonial interpretation of international law, that actually international law is used for some subjugated states to assert their rights in the UN and to harness the anti-colonial movement. Again, feminism, right? There's also been a feminist outlook on international law, that it gives rights and obligations or equal rights to women in society. So with all of these interpretations, whether it's Marxist or free market, or if it's colonial, anti-colonial, international law, really, you could say it's doing its job. It's equally managing to annoy every single sector of society, or maybe it's pandering to every single sector of society. And this just shows you that international law is what you make it, and politics will always influence international law in a variety of different ways. I think the best way just to look at politics and international law is that international law is just the sum of what the states want it to be. And more often than not, what states really want is a peaceful and a progressive society, and for everyone to become really, really rich. So if that's the idea, as long as that's the main purpose, then the methods will probably come into parallel lines eventually. Now, the second issue I want to deal with is nationalism, again, very closely linked, and something that's been heavily influenced by politics, especially. Sometimes one of the criticisms of international law is that it's just too intrusive, that these states have fought for independence for a long, long time, that there are processes and historical achievements from gaining independence. And then so to give up some of that sovereignty for an international legal system is simply just goes too far, right? And so international law is becoming a bit too intrusive. And so what happens sometimes is that these states begin to look inward, right? They look to solidify domestic policies and domestic institutions at the expense often of the international institutions. What's obvious is that, rules such as prohibition of torture or prohibition of slavery, these are pretty much rules that the majority, every country follows, right? They will happily agree on this kind of stuff. And so it's okay for international law to legislate on these issues that everyone in the world agrees on. The problem comes when international law starts to dictate things such as climate change policy and trade law, for example, right, in the coming and going of goods. And this is where countries can often find that international legal institutions are becoming very intrusive, and so they become very scared and turn inwards. And you'll find that this is pretty much exactly what has happened with these two scenarios, one being the election of Donald Trump, a populist figure, a kind of make America great again, an anti-internationalist, and also Brexit, right? The EU is a form of an international organization, and the EU then essentially is a form of international law. And so by Brexit, what people in the UK, at least the majority of people, said was that, well, we don't want to be bound by the laws of the international community or the European community. We want to be bound by the laws of Britain. And it's not just Trump, right? These populist voters that espouse sort of national voices, this is popular in some of the biggest countries in the world, India and Brazil. The challenge for international law is actually just finding a balance between being not too intrusive so that some states become bad apples and withdraw from EU treaties and, international treaties and conventions, and are now no longer subject to laws and regulations. And on the flip side, you have to make sure that international law is not too lenient either, because then otherwise countries, big powerful states such as USA and China and these kind of countries will begin to use their power, flex their muscles, and create global monopolies. Eventually that will lead to catastrophes, war, power hierarchies, and power dominance. The third issue I want to look at is enforcement. Now, like I said in the introduction, domestic states enforce laws through the police. The police are given the authority as kind of like a legal gang to use force and to do whatever is necessary to get you to obey the law. In international law, there is no international police. No country can phone the international police force and tell them to come and stop another country from invading them or to apply international law. The idea is that, in a perfect world, that states consent to the law and they always follow the law, but that's never the case. UN peacekeepers have been deployed, but that's not international police. UN peacekeepers are literally peacekeepers. They can only act in self-defense. They're there to calm hostilities between fighting parties. They're not there to take a side or to enforce law or anything like that. You could argue that the US sometimes acts as an international police force. Again, is that a good thing? Probably not. It's made mistakes in the past. Its invasion of Iraq, for example, was pretty much an entire violation of international law. It's not a great upholder of international law itself. There is an idea that maybe you can designate the UN Security Council to form a military and go and impose international law on countries. Well, that's okay if, for example, Botswana violates international law. But what if China violates international law? What if the US violates international law? These countries are on the Security Council. So are they going to invade themselves? Probably not. It becomes a big problem, enforcement in international law. It's always been a problem. And so the only way really to enforce this is simply to trust that states will uphold their laws and obligations. And probably the only way to do that is to make international law favorable. So as long as it's, keeping peace in the world, as long as it's making people rich, as long as people are happy, people will follow law. If not, then that becomes a problem. So the final area I want to look at is technology. Now, I'm only going to touch upon two main issues in technology and international law, perhaps issues that I have a personal interest in, but there are a bunch of other issues. There are lots and lots of articles about the role of technology in law. So you may all know this man. His name's Elon Musk. He's pictured there top right. And he's previously said that one of his main goals in life with his company SpaceX is for the human colonization of Mars. And that being probably for a number of reasons. General curiosity, the fact that global warming is imminent, perhaps the planet cannot hold human life for too long, especially at the rapid industrial rate that we are using it at, and the fact that, Mars has been shown to support some forms of human life, right? And so he has publicly come out, him along with six or seven international space agencies, that they will be looking at colonizing Mars. Now, what happens when the first humans do arrive in Mars? Who gets control of the territory? International law is going to play a huge role because, when you look at the first ever humans to step on planet Earth, we had no concept of law or technology or anything like that, right? Today, we're essentially colonizing a new planet, yet with all the information and knowledge that we've had through centuries on a different planet. So who gets a piece of Mars and what's going to be the role of international law? Again, something fascinating to think about for the future. The other issue that I'm really interested in, which involves international law, is the idea of network states, right? So it's this idea that territory is becoming less and less of a burden on human beings, right? And essentially it's to do with employment and work. So before technology, the main idea was that your job was always tied to the territory where you're in. So for example, if you were working as a doctor in France, your job would only exist in France. You would have to be in France to do your job and to make money. If you were, then you could move to Germany and to become a doctor, but then you would have to physically move territory to Germany to become a doctor. Now with technology, we're finding that this idea of work from anywhere is becoming more and more prominent. There are lots and lots of people who work for US companies. Their job is entirely on a laptop, and they'll move to Thailand for lower living expenses, yet all they need is a Wi-Fi connection to do their job, and the money's coming in and people are getting services and everyone's happy. So when you start to disconnect territory from work, I think that will have fundamental impacts on the idea of countries now. So then the idea is that the most important aspect that gives a state its right to govern people is no longer territory, it's networks in the future. So it could be a case that these artificial borders based on territory that we've created, physical territory, could no longer be as relevant. And we have these things called network states where you have an entire country based upon the networks between different computers, right? And it's no longer that you get the passport of the country that you're born into or the territory that you're born into. It's actually the passport of the network that you're born into. Now, again, I'm looking at a future from a movie or something like this, right? A very, very interesting area. And so how will international law and cybercrime law start to interact with different networks starting to negotiate with each other? It gets said time and time again, and at this point it's almost like a cliche for me because I've studied it for so long, but international law is exactly whatever states make of it. I think when you analyze globalization and international law, overall. It's almost as if it's a train that's never going to stop. Once you expose human beings to more and more and more growth, more and more potential to see different things, to experience different things, to meet new people, it's something that's unstoppable. And so regardless of populist nationalist government officials who say that we are better as one nation and we're better as a single territory that should shun the international community, it's pretty much an impossible feat at this rate. It was an impossible feat to get to this point where lots and lots of these countries interact with each other. And now I think it's impossible, equally impossible, to go back to where we were before, where countries are isolated, where territories are isolated, and they don't trade and they don't cooperate with each other. Thank you so much for watching this online course. It's my second online course. Hopefully I'll have more to follow as well. But again, if you have any questions or if you're interested in legal tutoring, I'm happy to do so. Just email me. And I hope you're successful in your legal career or any other career in the future.